They really set the minimum standards that are out there for an employer that employs from their first person onwards. So it doesn't matter if an employer is employing their first person, or it doesn't matter if they're hundreds or thousands of employees. These are the absolute minimum standards that have to be kept in place.
Welcome back to The Business Behind Your Business. I'm joined again by Paul Cripps, our resident HR professional and expert. And why have we got Paul back again, you're asking? Well, the reason is that HR employment issues continue to be one of the top three, and in many cases, the top issue for employers and business owners these days. And just recently, I've had a number of questions come through from my clients on what I consider fairly everyday employment requirements or requirements of employers that must be adhered to, yet I'm hearing noises that some of these, what I think are quite common, are not known. Now, we're going to talk about this issue, or not an issue, but the National Employment Standards. Now, if you're hearing that for the first time, you need to keep listening because this is really important. Paul's nodding his head as we're speaking. Paul, why are the National Employment Standards so important?
Hello, Paul, and hello to everybody who listens to the podcast. And look, the way I would answer that is that they really set the minimum standards that are out there for an employer that employs from their first person onwards. So it doesn't matter if an employer is employing their first person, and it doesn't matter if they're hundreds or thousands of employees. These are the absolute minimum standards that have to be kept in place. So very much as you said, Paul, every employer, and that not when I say employer, that could be employer, even someone that's just employing one casual member of staff, needs to be aware of these particular conditions, because if they're not, unfortunately, there is penalties that could apply.
So the National Employment Standards, they're mandatory. And as you said, even for one employee. If I'm the only employee of my business, do they still apply to me?
Yes, they would do, because it doesn't matter even if you're the business owner and the employee. Yes, they technically still apply to you as an employer.
Because that's one of the questions we've been asked regularly is, okay, surely if I'm the only employee, or if I'm the employee of my own business, these standards don't apply to me. I don't need to comply with them. I don't need to keep the records that everybody else, or that I have to keep for all my other employees. But that's not the case. Now, I think there is an obligation as an employer that you must present these standards to any new employee. Is that correct?
Yeah, that's right. I mean, they're all covered in. So when an employee joins a business, every employee should be given what's known as a Fair Work Information Standard. That's actually a provision that's actually in the National Employment Standard itself, and that sets out the minimum terms. That's something that should go out to any employee, and it's not hard to get hold of one of these documents. If you Google it, they're very easy to download from the Fair Work website in a PDF. My tip basically is just to keep it in a file. So it's something which is easy to send out. Just be aware, though, that whilst the same version of the document actually applied for a number of years, they now do update it regularly. So it is worth looking at and making sure you're using the right version. And secondly, if you're actually employing a casual employee, you now actually need to give them two statements. You need to give them the Fair Work Information Statement and the Casual Employment Information Statement as well.
Mm-hmm. And we've had a previous discussion on these changes to casual rules as well. So if you haven't caught that episode, look it up on your favourite podcast player, or go to the Business Behind Your Business website, and you'll be able to find that discussion on casual employment standards.
That's right. I remember that one well. And actually, I guess probably in that it's a case of, and it's once again that's been an evolving piece as well. Even since we did the podcast, there was some firm decisions out there, so that gives a good guide. But for anybody that is looking at, but they've got to be aware in terms of making sure that they're actually the judgment that came out on that they're applying that. But the statement is fairly straightforward in its own right in terms of the obligations for the employer. So that in itself gives a lot of detailed information.
Okay. So let's have a closer look at what's actually included in the National Employment Standards. And I think there's 11.
There's 11 in all, and we've just covered number 10, so that's fine. I don't like going in order anyway, so I'm happy to jump around, but there is, yeah. So would you like me to go through those, and we can just discuss those as and when we need to?
I think that sounds like a great way to approach it.
Yeah, so these are the movement standards. So basically the first one is about hours per week, and it talks about a maximum of 38 hours per week plus reasonable additional hours. Now, that's always an interesting word. The word reasonable comes in a lot to a lot of employment legislation. So what that means in practice, an employer shouldn't require someone to work more than 30 hours. But you raised a very excellent point there. As a business owner, it could well work in additional hours, and that's done really out of choice, noting the kind of role that somebody is employed to do. And here to talk about employment contracts in detail, but a lot of employment contracts will include clauses in there that talk to actually these are your working hours, plus you will be required to work additional hours that are an inherent requirement of the role, or words to that kind of effect. Nobody should quote me on this because I'm not a lawyer, but those are the kind of clauses that you tend to find in contracts, and that will be different for different businesses. So but as a rule under national employment standards, there's a maximum of 38 hours per week. Some people might say that'd be nice, but obviously you've got to be aware about what might be in different contracts there. If I can go to the next one, Paul, the second one is actually, these are presented in a little bit of an odd order, but is requests for flexible working arrangements. Now this has changed over the years as well. So some examples of this include, so it actually is an employee has a right to actually request. Now, it doesn't mean to say that has to be accepted, and this comes up quite a lot. There's a difference between a right for an employee to request a flexible working arrangement and an employer having to agree to that. And once again, in terms of, this could be a whole subject in its own right, but at its base level, it's about, if there is a flexible working arrangement that's going to be declined, it has to be for good reason. So it just can't be declined just because the employer doesn't feel like it, and whatever it is, it can't be discriminatory. So there are categories of people that actually are eligible to actually request for flexible working arrangements, and some of the most common are parents of children. Sorry, not children of parents. We come to that. Are basically parents with children of school age, and that's one that did change a few years ago. It used to be a lot younger than that, but it also includes. It does include people with elderly parents as well, and things like people with that have carers responsibilities, people with disabilities. So those are some of those. There are a lot more categories in that as well, but I guess probably the key thing there, it's a right to be able to request a flexible working arrangement rather than an employer having to make sure that they abide by that request.
Mm. So it's really it's not an entitlement, but it's a request, and unless there are a reasonable request should be granted under the standards, which is very different to how I guess the environment was, I guess, 10 years ago.
Yeah, it is, and I suppose I think probably the last 2 years, probably with COVID coming around, is probably that flexible working requests have become even more common. And so I wouldn't be surprised to see some further revisions to this in time. But and you're absolutely spot on, Paul. I think that certainly 10, 15 years ago, there were relatively limited rights here, and those certainly have been extended, and employers have had to adapt accordingly.
Okay.
The next one, number 3, is parental leave and related entitlements, and I guess we're probably there with. And once again, this probably is when I look at policies that cover this, is probably one of the most lengthy policies and detailed intricate of any. But at its very high level, any employee is able to, if they've worked for an employer for more than 12 months, are entitled to 12 months of unpaid paid parental. Now, this is different to the paid parental leave system that comes through the government. They're entitled to that by default. So effectively what it means is keeping the role open for 12 months. And that also includes, that can be shared, that can include adoption leave. Someone that I know particularly well a number of years ago, I went through adoption leave and actually shared that. So it was actually shared by both adopting parents. So there are various different provisions that are in there. So it's, you do hear of scenarios. Sometimes it's not how traditionally it would have been years ago, where that's a benefit purely to somebody that's female that's having the baby. There's a lot of different intricacies in that these days, but certainly there is an entitlement there for someone that's had worked for 12 months to work for a further 12 months, and then the government paid parental leave is there as well. It's an interesting one because I've actually come across a scenario with a client recently who'd moved in through different industries and was quite surprised that their employer was not offering, well, basically they weren't offering anything in addition to the government paid parental leave. But my experience in the small to medium-sized market is that that's common practice. I don't know whether you're aware, Paul. I certainly don't know of really anybody that's offering more than that. I'm sure there are others out there that do, but typically I find that it's something, it's a benefit that's probably not affordable to extend for a lot of small to medium-sized businesses.
Yeah, certainly if somebody in a small to medium business, if they're very key to your operations, then having them absent for 12 months can have quite an impact on a business. But then that leads into a whole host of other things that as a business owner you need to be aware of in terms of like how much do you depend on a key employee and what role do they perform. But yeah, I think the standard provisions are what most employers accept, and it's very rare for them to go over and beyond those. There'd be exceptions, but I think they are just what I said, exceptions to the rule. Not
it was interesting because to run it one past you as well, Paul, because certainly my experience is that in the corporate world, yes, but it's a corporate world with a few more deep pockets out there, but not my experience in the SME world. If that's so cool, well, I might jump into number 4 is annual leave. So annual leave, there is entitlement to 4 weeks paid annual leave per year. Without going into too much detail, that's obviously pro rata for part-time employees, and also there's an additional week that's there for certain shift workers as well. But that's always one to delve into more detail if it actually applies. But I think what I find on this, because it all sounds so simple, but from my experience, and I've come across this 3 times in the last 6 weeks, where I've come across and talked to people, whether it be existing clients, prospects, or people in my network, where they haven't actually kept records on annual leave, or haven't certainly kept proper and accurate records on annual leave, and that's I'm finding that's about, it can be scenarios where that becomes a real problem, and a couple of those, those examples I've come across have been where there is somebody that's in the process of leaving the business, and there's a lot of ambiguity that's out there. So look, it's not a difficult thing to do. There's a lot of software solutions that cover that, but certainly that's something which it sounds so straightforward, but in practice, I'm finding that there's people that are really falling over on that one.
Mm. Yeah, even the most very basic payroll systems now cater for annual leave to be recorded easily. I'd say probably the issue I see with annual leave recording is coming back to this question about the business owner when they are an employee as well. Is that the person's annual leave records as the business owner are usually not the ones kept. They're the ones not recording when they've taken annual leave, and they don't tend to care about how much is accruing there. But I think this whole aspect of annual leave, there's a lot of questions that come out of it, such as like, when you can take it, can you, how much notice do you need to give? Can an employer refuse it? Can you cash it out? What about leave loading? There's a whole lot of extra questions that we could answer or look at on annual leave, and maybe that's another discussion.
I think it might be, because I think we might have actually covered this, a little bit of that on a previous podcast with Ben, I think, as well, off the top of my head, in terms of enforcing annual leave. But I think once again that could be one that could actually be a bit of a subject in its own right in terms of leave. I think that but I totally agree. I think having a system in place, and look, my view is always as well, it's good to have a policy in place that spells a lot of these things out as well. Leave loading being a classic example is that some employment contracts will be set out in such a way that leave loading is inclusive of the entitlement. But obviously that's not the case if employees is paid purely on the award rate, because they need to obviously pay that then. But you're absolutely right, Paul. I think probably that one, and probably the next one, if I may go into number 5 as well, 2 that could go into all sorts of different detail. And I do get a lot of questions around. Number 5 is actually...
Oh, absolutely.
Yeah. Personal leave, carers leave, compassionate leave, and family and domestic violence leave. So certainly there's a whole these days bucket there, which traditionally people would have known as sick leave. It's more titled as personal carers leave, but it's also inclusive of passionate leave. So compassionate leave. Sorry. So the entitlement is to 10 days of paid personal stroke carers leave, and that's pro rata part-time employees as well. And within that, not in addition to this, and this is something that does come up, within that 10 days, there could be 2 days of compassionate leave within that 10 days. And there's also the option for 2-day carers leave as required. Now, in practice, what I find is that if the employee has actually taken their 10 days paid personal care, 2 days is a very odd number to come up with in terms of additional. Sometimes I find that employers typically may grant more than that, and certainly I would advise employers not to be very cautious about taking action if an employee has taken more than that. So sometimes it's another one really where I tend to find is a carefully drafted policy or contractual wording around this, preferably a policy, because it can change, is also it's something which is good for an employer to put in place. But a whole issue in itself is that one. If that's okay, Paul, I'll go on to number 6, which is slightly more straightforward. So number 6 is community service leaves. This is unpaid leave as a minimum standard for various things, which could include people that work in voluntary emergency services. It could be leave for jury service. Of course, in practice, a lot of employers may actually cover some of that, but as a minimum standard, it's there for that, and it's that can be up for up to 10 days for per annum for things like jury service. So that's one. It's an unusual one. I mean, yes, I find that it's something I don't come across very often, but there certainly are people out there that volunteer. There's certainly plenty of people that go on jury service, but it's something that needs to be granted in its own right.
Yeah, it's one of those newer provisions, but I think it's addressing a change in, I guess, our lifestyle and how we live, and particularly of late with the floods and the emergency work, and thinking back even just 3 years to the bushfires that we had quite a lot of. You wanted somebody to be looking after that or attending to that emergency, but when they were your employee, how do you provide for that? How do you look after your employees in that situation?
Absolutely. And I think there are
making it, I guess, a standard.
I think there are some employers that will do more than the minimum standard as well. I guess we're still not here what the minimum standards are, but you're absolutely right. It's, in terms of voluntary emergency services, we do need a lot of them in Australia. With floods, fires, or COVID as being the flavour of floods and fires seem to be more common. Hopefully COVID won't have another pandemic for another 100 years with any bit of luck. If that's okay, Paul, I'll go on to number 7. Number 7 is long service leave. And this is something that's not modern. One of my favourite tasks is often to explain leave provisions to where I'm actually dealing with an overseas, where perhaps I'm working with an overseas parent of a company that operates in Australia, either with someone in the business or sometimes dealing with another HR person. And long service leave is always one of the most interesting ones when you talk to them about the legacy of it. And I think the other thing to be aware of long service leave, it's very much state driven. I'm a lot more familiar with New South Wales long service leave than other states, but there are obviously some differences from state to state. That if a business is operating in several states, you need to be aware of the long service provisions in each state. The one thing I would say, and this is on New South Wales, that there are some good calculators. So there is actually a long service leave calculator that sits in a website with the name of which I completely forget. We'll put it in the notes if that's okay, because I'll find the link and send it to you. And it's a good calculator for businesses in terms of if they're unsure of that. But what should happen though is that hopefully, if you've got employees who've been operating business long enough that are entitled to long service leave, hopefully you've got that recorded somewhere in a system that keeps you completely up to date in terms of what you should be accruing. Because as you would say, Paul, it's something that sits on the bottom line of a business. So leave provisions. So it should be something that where accurate records once again are kept. I'm going to go into number 8 now, if that's okay, which is public holidays.
That's one of those ones that I see a lot of employers ignore. They ignore that one and don't provide for it. So, they don't switch on that recording in the payroll system setup.
Really?
And they fail to take account of it. And it's a risk for a lot of employers because they're not aware of their obligations to pay it. And it's actually a liability that hasn't crystallized, but it's one that they should be preparing for, and particularly from a cash flow point of view. So if you've got a long-term employee that is going to be taking annual leave, long service leave, if they resign and you haven't provided for it, there's a big hit to your cash flow. So encourage people to start tracking that in their payroll system.
Absolutely. I almost think in terms of you can't start soon enough, because one of the things that occasionally comes up, once again, it differs from state to state, but there are provisions that if somebody leaves a business after more than 5 years service in New South Wales, under certain situations, the most common ones are ill health and redundancy, they're entitled to a pro rata payment. And I find sometimes that's something that tends to get forgotten or missed. And once again, you're absolutely right. If that comes up, then that's a big cost that the business may have not been accruing for. So, as you said before, Paul, keeping records on this early is critical. And we're going to go to number 8 now, if that's okay, which is public holidays. Quite a straightforward one, is really that employees are either entitled to a pay day off unless they're requested to work. And if they're requested to work on a public holiday, there tend to be 2 options. Either they're offered and given an alternative day to take off, or they're paid an appropriate rate of remuneration for working on the public holiday. So, I mean, apart from stating the obvious, that once again, if people are operating in different states, and even just within different states, public holidays do vary. Whilst we have some national public holidays, we also have some that vary by state and region. Number nine is notice of termination and redundancy. And once again, there's actually a good little calculator which we can put in the show notes here as well, Paul, that helps employers actually work out, very easy one that helps employers work out their obligations here if somebody is leaving, in terms of whether it be notice of termination and that basic end, and redundancy pay, which may be payable as well. I mean, redundancy typically is not payable under the Small Business Code where there are less than 15 employees. But as I always say, it's always best to definitely get advice on that one, because if you've got an overseas entity, that also counts as well. So but if there are genuinely less than 15 employees in the business, and I'll say globally, then that isn't payable. But that calculator is very easy for employers to use to work out their obligation. And then we come to number 10. We've covered. So number 10, I'll just repeat this one again. So it's basically it's provision of a Fair Work information statement, which really in effect sets out these standards, and where required as well for a casual employer, casual information statement as well. Now, and then we come to number 11, because there's always been 10 national employment standards. The casual changes came out with number 11. So number 11 is the right for casual employees to become permanent employees under certain conditions. And once again, that's something which we've had some initial conversations about already, or in a previous. Things have got a little bit updated since then, and I won't go into a lot of detail, but there are conditions under which a casual employee can request to become a permanent employee, and an employer can refuse that under certain grounds, and also an employer can say, look, we've considered this, but we don't believe this is something we can offer at this time. So it's really a two-way process in terms of casual conversion, but it's something that's fairly new, and it came out about 12 months ago now, and there was a 6-month timeline to make the changes. So it all sort of like came in what I call the COVID era. So, and I get a bit concerned about certain changes that occurred in the last 2 years that I certainly find a lot of employers basically have missed all that. And I'm still getting queries that come in now in relation to that. So this is something which, if you've got if your employers listen to this for the first time, don't worry, you're not alone. I still get regular calls every few weeks about this, and the important thing is to not ignore it and hope that it won't.
Yeah, there have been a number of changes that we sort of we've been focusing on the COVID conditions and changes and business support in the last couple of years, and we've probably, I guess, taken our eye off some of the legislative changes that have come through, and particularly around employment and taxation is the other main area. But got to be aware of it, got to keep up to date, and it's worth checking in there regularly. Yeah, and look, there's one other little thing that we've been talking about that's not actually included in the employment standards. Well, actually, it's not a little thing. Well, there's two things, actually. There's record keeping and pay slips. Now, I just want to touch briefly on pay slips, because we're going to have another conversation, and we're going to go into a lot more detail about record keeping in terms of obligations and how long and what's included and how you should go about it. But pay slips is still a bone of contention with a lot of people. Can you shed some light on what are our obligations with?
Well, first of all, the obligation is to actually have them. So you must produce them for every employee. And now, I'm not a payroll expert by any stretch of the imagination, but there are various items that need to appear on there. So there should be a good breakdown in terms of the hours worked. Certainly in terms, obviously, from a tax perspective, how things are broken down there. The superannuation details should go on there. I'm also, and this is one I'm unsure about actually, Paul, I'm also a fan of when there is clarity around leave balances as well. I tend to think if leave balances go on pay slips, people know where they stand. I do know that sometimes...
Yeah, look, I think some employers choose not to put leave on there. But
they do.
Look, I think it's best. It's good practice, and it's also a good way of, in having good relationships with your employees, that you're upfront about what their balances are. I know some
Absolutely.
Employees didn't like to show how many, well, I was about to call it sick leave, but personal and carer leave days that were accruing. Because I know in past times, somebody would view that, okay, I've got 10 days I can take off without, before I'm missing pay. But
yes, absolutely right. And yeah, no, I've come across a fair bit, and that's probably the most common reason why people don't like to include personal leave on there. Is that particularly if let's say an employee with a number of years service that might have 100 days personal leave banked up, but I also, I suppose it sounds terrible, I've come across situations whereby in some cases it's given employees that are actually really good employees comfort, particularly in terms of if something, something really terrible happens health-wise, that they have got the support there because they, quite frankly, they have actually earned that over the years they've been working with that employer. But you're absolutely right, Paul. There's certainly there's certainly a lot of resistance, and that's probably the most common thing I find that employers switch off.
Yeah, and look, it comes back to, I guess, one of my, well, what I like to say regularly is that if you're running the business to be the best business you can be and the most profitable, then it's not just a case of what do you do to comply with the law. It's what do you do to get the best out of your employees? What do you do to run the best business you have? And if you're creating something diversive or divisive with your employees by not wanting to show them what their entitlements are, then I think that reduces the trust factor. You want your employees to be really working for you and helping you to grow your business.
Absolutely right, spot on. And you must silence me at this point, Paul. Otherwise, I'll go into that whole culture conversation, which we've done in a previous podcast. But very briefly, that's just that is one basic out there of setting the right culture, and trust is an absolute plus point. If there is good trust that's in place between the employer and the employees, that's a very good cornerstone behaviour to have in place for success, and which will help grow that business.
Yeah. And look, I think that's an important motivator. And look, if that doesn't motivate you and you are still listening to us, there is a monetary motivator for doing the right thing. And that is if you don't do the right thing, there are some substantial fines. Looking at in excess of $66,000 for a company for breach of the National Employment Standards. That's a fairly hefty penalty. One to avoid.
It is. That's right. Exactly right. And I think, as you know, Paul, it's a case of these things aren't just there as idle threats that they never apply. I remember putting something on LinkedIn at the start of COVID about certain things that I had one particular client that had at the time had a comment and said, "Oh, surely the employment laws won't apply because we're in a global pandemic." And I said, "Sorry, it doesn't. It's not an opt out in terms of." Contractual and legal obligations, and there's certainly been a number of cases where employers that didn't do the right thing then have been subject to penalties.
So we don't want to finish on that bad note, just recapping the purpose of the National Employment Standards and these rules.
Yes, certainly, Paul. Yes, look, they're there to set out minimum standards, and look, some of them are more straightforward than others, some of them are more complex, but it is something that should be basically every person that employs somebody, even if they're actually a business that actually with one employee that's themselves, so not a sole trader, but someone who employs themselves, PAYG, their minimum standards that are there. And look, from my perspective, I think we very briefly touched on this, and this is probably certainly a different conversation. But one of the some of the things to put in place, as I see it, really probably three good record keeping, so a good system that keeps the records in place. Having a well-drafted employment contract in the first place, and policies that are actually relevant and right for the size of your business and the type of the business you're operating. And then having those in place actually makes it a lot easier to manage the national employment standards and beyond.
Fantastic. So we're going to put links to where you can access the National Employment Standards, because you do have to give them to all employees. And we're also going to put links to how you can contact Paul Cripps to find out more about what you can be doing as an employer to make sure you meet your obligations. And I'm sure Paul will be delighted to have that conversation with you.
Certainly will. Yeah, thank you, Paul.
Great. We'll catch up with you shortly to continue those discussions on those other issues we raised during today's interview. Thanks for listening. Do you have a question you'd like our team of experts to answer? If you do, send your question to podcast@thebusinessbehindyourbusiness.com. To hear more from The Business Behind Your Business, don't forget to subscribe using your favourite podcast player. Or you can visit the businessbehindyourbusiness.com website.